IMH Special Asset NT168 LLC et al. v. Beck. Our case number 1CA-CV19-0156. Each party, we have 20 minutes for you. Appellant, if you want to reserve your time, you're free to do so, but you have to keep track of that yourself. We don't keep track of it for you. We've conferenced this case this morning via video conference. We've read the briefs, reviewed the record, so keep that in mind while you're making your arguments. Parties, we would ask you or let you know that this is being recorded and we'll later post it to YouTube. So when you begin your presentation, please identify yourself and state who you represent. When you're not speaking, we'd ask you to mute your microphone, but leave your camera on so that we can see you. I think there's another attorney who's not arguing today, who's in here, but please have them mute their microphone and they can turn their camera off. With that, is there anything from Judge McMurdy or Judge Cruz that we need to cover before we begin?
No, thank you.
No.
All right, excellent. Appellant, you may begin.
Thank you very much. For the record, it's Christopher Bailey, Snell and Wilmer, on behalf of the appellants. And can I confirm that everyone can hear me okay?
Yes.
We can.
Okay, thank you very much. May it please the court. Good morning, everybody. Good morning, Mr. Sanis as well. I really appreciate the opportunity to be able to speak to you all. Taking the court's comments to heart about conferencing and having read everything, when I was thinking about what I wanted to leave the court with respect to this particular appeal, I've thought of three things. The first thing is that I want to emphasize to the court that the trial court below failed to enforce the clear and unambiguous receivership injunction, so making the appellee's actions void as a matter of law. The second thing is that once the trial court embarked on this partnership governance dispute, which is essentially what it is, the court failed to recognize that after the discharge of the stockholder receiver itself, the court lost jurisdiction to resolve the dispute between the limited partners and the general partner of RNMA, which is Recorp New Mexico Associates. And the third thing is that once the trial court conducted or actually concluded that the appellee had removed RPI, which is Recorp Partners, Inc., as the general partner, the appellee had waived his right to replace RPI with another general partner under the express provisions of section 19.3 of the partnership agreement itself. But I'll turn to the first argument, which is the gating issue for everything in this particular case. It has been raised by my clients since November of 2016 and will be continued to be raised here. The appellee violated the express receivership injunction that was embedded in the order appointing the receiver to begin with. Now, this injunction is fundamental to all receiverships. Upon the appointment of the receiver, the receivership estate is created. So as of that time, all assets, all liabilities, everything that is supposed to be administered by the receiver is then contained in that receivership estate. This receivership estate must remain essentially inviolate. It has to remain free from attacks by third parties to enable the receiver to actually do its job. So as of the time of the appointment of the receiver and as of the time of this particular action in November of 2016, the stockholder receivership estate consisted of various stock interests in several Arizona corporations. One of those Arizona corporations was Recorp Partners, Inc. Now, to understand that the stockholder receiver was the 100% shareholder of Recorp Partners, Inc. And Recorp Partners, Inc. was the general partner of the limited partnership known as RNMA. The stockholder receiver had all of the rights, duties, responsibilities as the owner of Recorp Partners, Inc. And Recorp Partners, Inc. had all of the rights, duties, and obligations of the general partner of RNMA. So if we, Your Honors, we take a snapshot in time as of November of 2016, before the action that was taken by the appellee, which is the sending of the notice of the removal, the stockholder receiver could and had all of the rights inherent to ownership and could market and sell the RNMA real property or the attendant inchoate potential water rights. It could, as the general partner, it could sue other entities. It would have to then defend the partnership of RNMA if RNMA was sued. The general partner could borrow money. It was supposed to pay bills. It was supposed to file tax returns. All of those things were inherent and incumbent in the 100% ownership of RPI, which is the general partner of RNMA. After the appellee's action of sending the notice of termination, that was all gone. That was gone according to the appellee and eventually also the trial court below. The receivership estate was diminished because of that action. And that, Your Honors, is a stay violation. Now, there were two arguments that were raised by the appellee to essentially both acknowledge the fact that there was a stay, but to try to skirt the issue of whether or not the action that it took violated the stay. And so consequently, one of the first arguments raised by the appellee is that the receiver's rights were limited to just that of the stock ownership of the corporate general partners. And unfortunately for the appellees, there's controlling case authority from the state of New Mexico in a bankruptcy case, and it's in the In re Priestley case, and that's the Priestley case. That's bankruptcy court out of New Mexico, 1988, 93 BR 253 at 257. It's cited in the reply brief at page 8. And that New Mexico court said that general partners have three inherent rights. One, that general partner has a right in the specific property that the general partner owns.
Let me interrupt you for just a second, because
yes,
that's a federal bankruptcy case.
It is. It is. It's a federal bankruptcy case decision interpreting the New Mexico law on general partnerships.
Generally, we don't think of federal cases, even federalism and district court cases, as providing binding authority as to the interpretation of Arizona law. Are you saying that that's a binding? Because I think you used the word binding. I just want to make sure I understand that.
Well, it's a conclusion by a federal court that interprets underlying New Mexico state law. And so the argument that I'm presenting to this court is that applicable and controlling New Mexico state law as to what a general partner of a New Mexico partnership has in terms of assets are the specific property rights.
So your argument is that the law is binding and that we should find that the federal court's interpretation of the law is persuasive.
Well, if it's not binding with respect to the federal court's interpretation of the state law of New Mexico, it's clearly persuasive with respect to this court taking a look at what New Mexico law would do with respect to a general partner's inherent rights. So, yes.
Okay. Thank you.
Yes.
I didn't mean to
Sure.
derail you there. I just want to make sure I understood.
No, not at all. And the third thing, Your Honor, that I was just getting to, because you did miss my big punch, is that.
Hold on, before you give us the big punch, counsel, and before you leave this point,
Yes.
so
Right.
so in Priestley, the bankruptcy court highlighted the distinction between ownership shares, which deals with property purposes for bankruptcy law, and the right to manage, which is a contract right. And so removing stockholder as a general partner may have interfered with management and operation of the receivership estate if it were in that role, but removing RPI as general partner would not. Isn't that true?
No, but well, yes, it would violate it
Because the receiver stands in the shoes of the entity that it represents.
Well, that's correct. The receiver stands in the shoes of the 100% shareholder of RPI. So therefore it owns and operates and runs RPI. So whatever rights and benefits flow to the shareholder come from that particular corporate entity. So the value of that interest depends on what the general partner in that particular entity has. And at the time before the notice of the termination to terminate the general partnership, at that time it flowed all the way through, so that the receiver had the interest in the stock, which ran RPI, which ran the entire limited partnership. And when that general partner was then allegedly removed, then all of the rights to run that limited partnership and not only the rights, but the duties and obligations, the head of the partnership was cut off. And so therefore, whatever interest or whatever value that receiver had was essentially then removed and cut off. And so that's why it's so important that the right to participate in the management being acknowledged as an express right of that general partner. Once the appellee tried to essentially remove the right to participate in the management of the limited partnership, that affected the receivership estate. And that affected the value of RPI itself and the shares of stock that owned it, and then the shares of stock that were owned by the receiver. So it all flows together and it can't really be segregated. So I think at that point, that shows us that this clearly was an action that was taken that affected the rights of the receivership estate as a whole, both in terms of the right to be able to get distributions, to make management decisions, and so consequently, what ended up happening is so that the appellee tries to limit it and say, oh no, it doesn't affect anything having to do with the limited partnership. Then the second thing that it says is, but don't worry about that, court. Don't worry about the fact that we did that, because in essence, what happened is that after I terminated the general partner, I filed a motion in the trial court below here in Arizona, and I said, hey, stop the general partner from taking any actions because I removed it 6 weeks ago, back in November of 2016. So the appellee tries to tell this court that it's okay if it violates the receiver injunction in 2016. Then 6 weeks later, it files a motion and says, now court, I'd like you to enforce the fact that I violated the injunction. And essentially, I'm asking for retroactive or nunc-pro-tunc relief to say that when I violated it back in November of 2016, it's okay. And that's not anything that this court should countenance with respect to interpretation of injunction language in Maricopa County Superior Court issued orders providing for stays of enforcement. So
before your time runs out, I do have just some questions that I'd like to ask you.
Sure.
When it was alleged that RPI had been removed, I realize that you dispute that, but when was the arbitration actually, when was that actually filed?
Well, the request for, or the demand for arbitration was actually made earlier this year in 2020. It was after the trial court's ruling that came out in November of 2019. Hopefully I have these dates right, but it was the trial ruling came out in November of 2019, and there was the ruling by the trial court that said that the general partner had actually been removed. Until that point, we hadn't had a determination. And so consequently, after that, then we made the demand for the arbitration, and then that was caught up with respect to this pending appeal. So the arbitration has been requested and demanded, but it's never happened, Your Honor.
Okay, so there is, so just so I understand, there was a dispute about who, if the general partner had been removed, which triggered the arbitration clause, which then was not filed until, let's say, January of 2020. I mean, I'm just making this up on the fly, but
Understood.
So it was filed in January of 2020, and it goes to your argument about, well, if RPI had been removed, they've waived that right because they didn't appoint a substitute. Well, how can they appoint a substitute if they're in arbitration over that very issue on whether they have effectively removed RPI?
Well, they weren't in arbitration between November of 2016 and even up till now. So
yeah, but you were disputing it, right? I mean, you were disputing it this whole time. It's not like oops, we have a final order, whether it be from an arbitrator or from a judge, that you've been removed. And isn't that when they would have, when their clock starts to run on their 60 days to appoint a replacement?
I mean, frankly, Your Honor, I think that's number one. If we take the most charitable view, 60 days after the ruling came out from the trial court below, they should have appointed a new general partner. I would have, to be safe, I would have made sure that when I.
Is that a final order? And if it is, why are you arbitrating it? If it was a final order, then what's the purpose of the arbitration?
Well, and I guess that's a good question.
I try to come up with a good question, one in everything. Okay.
I know. No, and so that's part of what we believe to be the inherent flaws in the underlying ruling from the trial court, because once the court gets to that point and makes that determination, literally all the wheels come off at that point. And so when the court actually ruled that all of the actions that were taken, Your Honor, by the general partner from November of 2016 to the present were ultra virus because it had been removed as of that point. Well, that doesn't essentially jive with the question you just asked, and which is what the question is that's being posed by the appellants here, is how, those two things can't go together. So the trial court basically said two things. One, the removal was effective pursuant to the notice in November of 2016, and therefore has taken and made a ruling that all of the actions taken by the general partner after that were ultra virus and of no force and effect. Well, if that's true, there is no general partner, and then it should have been replaced. So if you win
in arbitration that no, there was no valid removal, doesn't that vitiate the ultra virus ruling of the court? I mean, because that's dependent upon that in fact there wasn't an appropriate removal. I'm struggling with this. Yeah, I'm trying to figure out. It seems to me that if it's a done deal that there was no removal, which you're arbitrating right now as we go, there's an arbitration proceeding in some fashion trying to determine whether or not RPI has actually been removed. Correct?
Well, no. Well, we haven't gotten there, but assuming that this
use that term proceeding loosely.
Okay, all right. I agree, but I don't know that an arbitration proceeding can essentially go back and change the ruling of the trial court of the ultra virus actions, because now, as it currently sits, according to this trial court ruling, nothing that was done by the general partner since November of 2016 until the present has any force or effect. And then you're going to have an arbitration that goes back and says, based on my finding that there was no good cause to remove them, then all of a sudden now that arbitration ruling somehow flips this. I think that the ruling is just wrong and needs to be fixed. I don't believe an arbitration, Your Honor, can essentially go back and change the ruling from the trial court below. So,
Counsel, before you run out, can you just tell me what is the basis for your attorney's fees request?
the attorney, well, right, this is something that we've been arguing about through the entire process. This is essentially an argument over the contract. This is a contract interpretation case. It has always been the appellant's position that this has nothing really to do with the receivership at large. What this is a dispute between the limited partners and the general partner with respect to corporate or partnership governance issues, and therefore fighting over the interpretation of the contract gives us contract law rights to have the rights for attorney's fees. So I have 1 minute, if I may allow to hold that for final comments.
You may. All right, counsel for the appellee.
Thank you, Your Honor. Judge Cruz, Judge Morse, Judge McMurdy, it's a pleasure to be in front of you, and may it please the court, Joel Sanis from Udall-Shumway, appearing on behalf of appellee Greg Beck. The appeal was a little bit unusual from my perspective in that the appellant elected to raise virtually every issue in the trial court below without selecting which issues were the most important and not being using discretion to determine what the main issues were on appeal. And then in our response to the appeal, we made the right ruling, wrong reason argument, which is an alternative argument. We thought we had the right ruling for the right reasons. But at page 27 through the rest of our appeal, our response, we argued why Judge Smith's ruling could be affirmed based on 3 other arguments or raised below. And the only thing that we received in response to that argument in the reply was that we did not file a cross appeal. So at this point, if we properly raise the issues under the right ruling, wrong reason doctrine, the 3 arguments we made for affirming Judge Smith's decision have been unanswered. So addressing the right ruling, wrong reason argument, IMH says that we were obligated to file a cross appeal, and they do cite the proper law on what a cross appeal is, and that is whether the result of the decision would alter the rights of the parties. But of course, the result of the decision, if this court affirms under the right ruling, wrong reason doctrine, is only to give Beck the relief he sought below. The test, I think, for right ruling, wrong reason versus cross appeal is whether the appellant would be worse off in terms of the result if this court affirmed for the other reasons that we selected. We did not assert a counterclaim. This is not asking this court to reinstate a counterclaim and give us judgment on a counterclaim in our favor. There was no appeal of a denial of attorney's fees. The only result, if the court affirms for the other reasons given in our brief, is that Beck has the same relief that he requested at trial. So I wanted to make that point in that those arguments for the right ruling, wrong reason have essentially been undisputed. And I don't know what to say except to repeat those arguments because I don't have anything that disputes them. So I think that the court can affirm the trial court's decision based on appellant's lack of response to the right ruling, wrong reason arguments. And of course, those 3 reasons that we gave for the right ruling, wrong reason were that the first one is that there really was no transfer of the 90.4% membership interest in Permit LLC, and because the pleadings that were filed below were inconsistent. The motion to wind up the initial receivership what we call the MCA or Bierman receivership, did not say that 94.4% of PERMA's membership interest would be transferred to IMH. It said the opposite. It said that PERMA would simply be dissolved. The actual order that was lodged is inconsistent. In one section, it says that PERMA would be transferred. In another section, it says it wouldn't be transferred and it would be resolved. It would be dissolved. The real objection here to the 90.4% PERMA transfer issue is that if it's determined that the windup of the Bierman receivership did not transfer the PERMA LLC shares to the receiver, or to IMH, that all of the other transfers are also impacted by that. I think that this court and Judge Smith could make a ruling that the only party that's complaining can set aside the one transfer that was involved in that transfer, and nobody else has moved to set aside any other transfers. And we also pointed out that Mr. Beck is unique compared to any other parties that might object to the viability and the enforceability of the transfer orders in the trial court. And the reason why he is unique is that at the time the motion to dissolve the Bierman receivership was pending, the trial court record shows that Mr. Beck had a conversation with Mr. Bierman and also with Mr. Reeves to ask them what the impact was of the motion to dissolve the MCA receivership on the ownership of RPI. And both of them told Mr. Beck that it had no impact because that had already occurred. So both receivers in this case told Mr. Beck that the transfer had already occurred.
Mr. Sanis, I have lost your video. I can still hear you, just not seeing you.
Your Honor, I do have my video on, and I can see my video.
Judge Morris, I can still see him.
Okay.
So can I.
Go ahead and proceed then.
I'm sorry. Yes, Your Honor. I can tell you I'm not much to see on video anyway. So that covers the issue on the 90.4%, but we also argued that the capital call was procedurally defective, and it was. That was our second argument for right ruling, wrong reason. It was procedurally defective. So even if RPI had the authority to issue the capital call, all of the issues for the removal notwithstanding, there's no good argument that the capital call followed the procedures of the limited partnership agreement. And then, of course, our last argument was that IMH was required to obtain court approval for the capital call and the July 2017 loans. Those are the things that are really at issue. When we talk about things being actions being ultra virus, it's those two actions that we are complaining about were ultra virus. And we argued that the trial court had to approve that capital call and had to approve the July 2017 loan. It's beyond dispute that there was still a receivership at that point. And we also know that the receiver asked for permission in November of 2016 for the first loan. Judge Mullins denied that and said it was an improper takeover attempt. And then 7 months later, or 5 months later, after her denial in February 2017, IMH did exactly the same thing without asking permission. So those are reasons why this court can affirm, irrespective of the arguments that IMH makes on its appeal. There is one other fact that I want to point out when it comes to the receivership, the argument that this was the action to initiate the process to remove the general partner violated the receivership injunction. As we point out on page 42 of our brief, the trial court's orders said that the PERMA LLC shares, if they're effective, would be transferred to IMH. And then IMH transferred those shares to the receiver. So what IMH did is it intentionally put its own ownership of, alleged ownership of PERMA LLC under the receivership, because the order said it would be transferred to IMH. So now IMH is saying that it unilaterally transferred its interest in PERMA LLC to the receiver, and then Mr. Beck's initiation of the process to remove the general partner violated the receivership injunction. We don't think it violated the receivership injunction in any event, but the only reason that the assets in Perma LLC were in the receivership in the first place is because IMH chose to put them into that receivership. And so now going to the points about the claim that Mr. Beck's notice initiating the removal process violated the receivership injunction. And Judge Cruz, you are correct that the action to initiate the process to remove the receiver did not remove stockholder as the general partner. Stockholder was not the general partner. RPI was the general partner. And stockholder owned, allegedly, all of RPI because IMH had transferred its interest in the Perma LLC interest to the stockholder receiver. So when they say that it was a violation of the injunction, what they're saying is that a receiver that owns a corporation can use the receivership to nullify and trump and invalidate contractual obligations of the general partner. Because this was a contractual claim that the general partner had been, the process to remove the general partner had been properly initiated. And now IMH is arguing that initiating contractual remedies against a general partner that is not the receiver violates the receivership injunction. That's the first reason why there was no violation of the receivership injunction. The second reason is that Beck notified the court of the vote of the limited partners to initiate the removal process and asked the court to rule whether limited partners acted according to the limited partnership agreement. What IMH is complaining about is that it has taken this long for the court to rule, but the court could have ruled within 10 days that what Mr. Beck did that what the limited partners did in initiating the removal process was either valid or invalid. The fact that it took over 2 years for that to be resolved is only an indication of the process. It's not an indication that Mr. Beck did not follow, did not notify the court of his actions so the court could determine whether they were appropriate. And IMH makes this very fine slicing of the issue to argue that Beck was obligated to ask permission of the court to even initiate the removal process, as opposed to initiating the process and asking the court if it was allowed, because it's undisputed that Mr. Beck filed a motion to ask the court if the removal process was properly followed when it filed what we call our take no action motion. The next point on that IMH makes is the receiver didn't have an opportunity to defend before the vote to remove to start the removal process. But the receiver's opportunity to defend is causing RPI as the general partner, or stockholder, as the owner of RPA, causing RPI to initiate the arbitration process. So it did have an opportunity to defend. It has just chosen not to initiate the arbitration process. They argue also that acts in violation of the receivership are void at the election of the injured party. Who's the injured party here? RPI was not under a receivership. It had obligations under the limited partnership agreement, but RPI is not injured by enforcing the limited partnership agreement. They argue that stockholder is injured because as the owner of RPI, it had an interest in continuing to control RPI, but that's the reason why we have corporations. The shareholder cannot say, I'm injured because you've injured the corporation. The shareholder can say, you injured the corporation and that affected my interests, but it's the act against the corporation that has to be evaluated, not whether the shareholder is an injured party. So RPI is not injured by having to comply with the contract, and the shareholder receiver is not the injured party.
Mr. Sanis, before your time runs out, I do have some specific questions I'd like to ask you. And it relates to RNMA's dissolution date. It's my understanding that there was an initial dissolution date, and that was in, what, 2005? Was it 2005?
Yes.
And and the limited partners attempted to extend the dissolution date, correct?
Yes.
Doesn't that attempt violate New Mexico law?
We are there's no the limited partners can make a decision to continue the general partnership until the general partnership is dissolved under New Mexico law. The fact that they acted retroactively to continue the limited partnership is that would be the question of whether the actions of the limited partners to continue the limited partnership retroactively violates New Mexico law. And I don't know if it does or not. We made the argument that it doesn't, and nobody's denied that the retroactive action by the limited partners is not effective to extend.
Well, if we determine that retroactive determination is not authorized under New Mexico law, don't we have to remand this back to the Superior Court to make a determination of when did it and what actions could be taken within the wind-up period, if that's the case?
I think that yes, if the court determines that the partnership was dissolved as of December 31, 2015, before the limited partners took the action to initiate the removal process, then we have to face the question of what rights did the general partner have to take actions after December 31, 2015. Yes.
All right. Thank you.
Mr. Bailey in his time didn't get to the jurisdiction issue. He only discussed the failure to enforce the receivership.
Hold on a second, I just lost sound. You guys can hear me?
Yes, we can.
Issue with earlier arguments.
Am I back up?
Sorry.
Just a second.
Judge Morris has dial-up modem at his house, and that's a little.
My dial-up's not working well. I can hear now. Yeah, I'm sorry. Where were we?
All right.
I'm beginning again. If anybody can.
Jurisdiction. Jurisdiction.
The jurisdiction issue, we pointed out, there's a contradiction in the jurisdiction issue versus the argument that there was a violation of the receivership injunction. In the jurisdiction argument, IMH argues that the limited partners should have filed a separate lawsuit against RPI, what IMH calls in its brief a plenary action. And so it says we could have avoided the jurisdictional issue by filing a separate lawsuit against RPI in a different court that didn't have an ongoing receivership and possibly in a completely different jurisdiction than Arizona. So when they say that there was a jurisdictional problem, they're actually saying that we should have violated the receivership injunction by forcing the stockholder receiver to appear in another court to defend its actions. And then on the jurisdiction argument, we also pointed out, and this is the problem with a very complicated case below, we don't even know when the stockholder receiver was finally discharged. In IMH's brief, they cite September 18, 2017, July 23, 2018, and May 14, 2019. And all of those dates, of course, are after Beck's take no action motion in January of 2017. So at the time that Beck took its action, the receiver had not been discharged under any of those dates. So if the jurisdiction is determined by where the receivership is, that's where we had to file it. If we had to file it somewhere else, and there'd be a much better argument for violating the receivership injunction. And then, of course, we pointed out in the Orcutt versus Crawford case that if an action is begun while the receiver is still under the jurisdiction of the court, the court can continue to hear that action until its conclusion, even if the receiver has been discharged. And we cited the California lumber case that said that any party has a right to question the actions of the receiver and challenge their validity if those actions are, if the facts arise later. In that case, there was a challenge to whether the receiver had a right to convey title to.
Oops.
Oh, I suppose he was done.
I just got a note asking that he was in the lobby, and I accepted him back in. I'm not sure.
Your Honors, I disappeared and then reappeared.
All right, you got 1:38 left. I think the last thing I heard from you, I can't remember now. You were talking about the dates.
This was just on the jurisdiction issue.
Yes.
Making arguments as to why the trial court did have jurisdiction.
Right.
So I have a minute left. I'm going to wrap up and say that I don't know what to do when we argue right ruling, wrong reason, and we get no response. I can't re-argue our points, and I don't know what IMH has to argue against our right ruling, wrong reason arguments. Otherwise, we would ask this court to reaffirm the trial court's decision for the reasons that the trial court gave. Thank you all.
All right, thank you. If you would go ahead and mute your mic. Mr. Bailey, I believe you have about 1 minute left.
Mr. Zane's camera is off. There you go.
There it is.
Did I unmute successfully?
Yes, we can hear you now.
Okay, all right, thank you, and I thank you, Your Honors. And I know I have less than a minute, but I think that what I've basically heard in the arguments we all heard from Mr. Sandus with respect to Mr. Beck's appeal is that he argued that the appellants were trying to take a very fine slice. That was the phrase that he used with respect to the violation of the injunction. And I think that as a policy concern for this particular court to suggest that Mr. Beck is saying that I'm going to take an action, and then after I violate the order, I'm going to come back later, and then I'm going to ask the court to rule on whether or not my order or my action was appropriate, is not something that this court should countenance with respect to its receivership orders, administration of receivership estates. It's got to be done correctly. And the bottom line is I find that it was they violated the injunction, and I know I'm out of time, and I appreciate the court's indulgence for allowing me to sit before you as opposed to stand. And of course, if there's any other questions, I'll try to answer them.
No, I think you've covered it all. We thank you both for your arguments today. I guess I should ask Mr. or Judge Cruz and Judge McMurdy, do you have any questions? Okay. Yeah. We thank both parties for their arguments today. We appreciate the briefing and all the hard work you guys put into this. We will take this matter under advisement and issue a written decision in due course. Thank you all. We are at recess.
Thank you. Thank you.